Hey everyone, Harry here to talk about another area of pushback by the courts, namely on the motions of January 6 offenders who have been pardoned for January 6 offenses and related offenses to have that pardon extend to other crimes. And that happened in a case last week in the Court of Appeals, and it happened again yesterday. We're in the district court, and the January 6 offender, Elias Costianes, and his motion is before James Bradar. And the basic idea, and of course what's tricky about these is typically the administration is joining. They're having a pro January 6 offender position and trying to, in fact, to both portray January 6 offenders in the most benign light, true patriots, etc. And some got a little out of hand, and also to give as broad a reading as possible to Trump's pardon. So this guy, because he's found in January 6th, there's a later search warrant, and it's executed, and he's got a gun he shouldn't have, and he's convicted for unlawful possession of a firearm. And he wants to say that the pardon already extended to him for his role in the January 6 offenses encompasses, in the arguably capacious idea of related crimes, this firearm offense as well. And, it's a season where the courts are really pushing back and scrutinizing. The judge here says, I don't see it necessarily. There's been a series of back and forth with the administration, and as they're wont to do, they basically were non-responsive or just gave positions without any kind of argument. So here the judge has said on a few occasions, what exactly is the connection between these two? Why should the pardon count? Now, what happens in this opinion yesterday is, under the law, and this is a cross-cutting problem generally, where people in the government and prosecutors get the benefit of the doubt. You don't assume their bad faith. And of course, we're now in a posture that, for the first time in my lifetime, where you sort of have to assume bad faith or lack of full candor if you want the law to really take notice of and respond properly to all that's going on. And the judge here does that sort of a little, because when you lay out the law, you need to find, in order to reject. They've made the same kind of motion as in the Eric Adams case, Rule 48, get rid of this case. And the judge says, not so fast, because under the law, I can't reject it just willy-nilly. On the other hand, and this is the take-home point from the opinion, I can't be a rubber stamp either. And the rubber stamp idea is, for the judge, expressed in the notion that maybe the arguments that they've made about why the pardon really extends, pardon-related offenses extends to the firearm offense, are really just not cogent, not solid, and there may be other reasons there. And so what he's done, he certainly didn't reject the Rule 48 motion, and as happened in the Adams case, the mayor in New York, that motion could well be granted to dismiss the case, but that doesn't mean, the judge is making it clear, he won't necessarily hold to the administration's interpretation of the actual language of the pardon. That's a sort of judicial determination and not something for Trump to do. Now, Trump could, if the judge says, sorry, this is not part of the January 6 omnibus pardon, Trump can pardon him again. Okay. But for now, unless and until he does that, the judge wants more information. And so for sort of about the third time, he is pushing back and saying it's not enough for you guys just to assert there's no bad faith, as would be required under the test. No one's given me really any information to do something I'm entitled to do, which is determine the meaning and scope of the pardon and how the later firearms offense, does it really come within its ambit or not? So he's ordered once again by next Tuesday. I want this briefing here. I want you, I know administration, you've tried to say it doesn't have to happen. I disagree. I want to hear it. And so, again, it's a situation in which the administration thinks it can just kind of come in and say whatever it wants, and especially here, because obviously the defendant isn't going to oppose its efforts to say, oh, the pardon covers it. And, a judge pushes back. And the other case that I mentioned, same thing happened in the Court of Appeals level, where the Court of Appeals said, no, you can still have authority, district court, to figure out whether a very similar kind of separate offense, whether that comes within the construction of the pardon or not. If it does, okay, he's already free and clear. But if it doesn't, he's got to, serve his sentence out, at least given or we will see what the judge will do if they find it that doesn't. But he certainly made it clear that he could just reject the Rule 48 motion by finding bad faith as he's construed it in the opinion. So another instance where DOJ came in a sloppy way and said stuff that didn't really hold up, or really didn't, not much reasoning at all. And the district court has said, nope, go back. I've asked for this material. I want it. See you next Tuesday with these briefs, and then we can decide. But I have to do my part of construing the pardon and evaluating as a judge your argument that this later offense just comes within the broad terms of the January 6th pardon. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.